The Law and You, a look at laws in St. Vincent and the Grenadines which affect our daily lives. The Law and You, presented by lawyer panel P.R Campbell QC and brought to you on SVG-TV as a public service.
Ladies and gentlemen, brothers and sisters, boys and girls, greetings. Welcome to another presentation in this public service nation building series, The Law and You. This is program number 985. Coming to you on Monday the 5th of October 2020. On this program, I will continue with the topic, the compulsory acquisition of land. This will be part 3 of the program and hopefully the last part for the time being. Before I get into the program, a few short preliminaries. As usual, my condolences go out to families which have suffered recent bereavements. And in that connection, I begin with our famous nation builder, Mr. Alfonso Denny, former Member of Parliament, former representative of North Leeward, former executive member of the New Democratic Party, and the father of a former lawyer, Olin Denny, deceased, and others. My condolences to all of the surviving children and all members of the family. Also, my condolences go out specially to the family of Miss Clydeth DuPont of Lodge Village. Clydeth, in the days when I was a parliamentary representative for the area, was a very good friend and strong supporter of myself and the party I represented, and friendly with everybody. Clydeth was such a lively soul in the village, she'll be sorely missed. Condolences, finally, to the family of the late Mr. Rudolph Joseph. He was formerly of Rockies, where we were boyhood friends. He was one of the Rockies fraternity, and then in later years he went to live at Lago Heights. But Rudy, as we knew him, was one of the boys in Rockies. And sadly, many have been passing. Rudy's claim to fame was that Rudy's mother, whom we call Mafan, on afternoons would stay at Top Rockies and shout at Rudy playing in the Richmond Hill playing field. And he would hear her clearly. And she would shout sometimes instructions to him as to what to buy on his way home, or that he should come home quickly. Mafan was an institution and Rudy was one of us. Sadly, few of us are still around. My condolences go out to the whole family on behalf of my family and on behalf of my brothers and the sisters and their families. And let me hail up two of the Rockies clan. First of all, Mr. Errol Kane. He operates a taxi on the taxi stand outside the administrative center, so I see Errol quite frequently. And if I have to take a taxi, he's my first choice. We grew up as boys together, his mother like my mother was like his mother. And I only see every now and then Brother Carlos Gaskin. Fling! Hope you're doing okay, and one of these days, Pastor Semina man. We old Rocky fellas should get together every now and then. Finally, I want to remind, in my capacity as Chancellor of the Spiritual Baptist Archdiocese, to remind the ministers, deacons, deaconesses, other members of the hierarchy of the Spiritual Baptist Archdiocese of our synod, which will take place this coming Sunday, the 11th of October, at St. Elizabeth Cathedral, Belmont, beginning at 9 o'clock. Synod this Sunday morning, 11 o'clock, as well as, in addition to the hierarchies, the candidates for holy orders, whether they want to be deacons, deaconesses, ministers. There would be a special session for you. All right, now I get to the topic, and the last program we really ran out of time. I had intended to read at least the first 6 sections of the Land Acquisition Act, Chapter 322, and I just barely managed to begin Section 2. So I want to go straight into the reading, but for the benefit of those who perhaps did not see programs 1 and 2 of this series, and if you're just joining this program and you're just hearing about this topic, for your benefit, let me recap briefly what I had been advising. Firstly, when it comes to government acquiring lands compulsorily, a distinction has to be drawn between government buying land, which government is free to do anytime, and government taking lands from persons on payment of compensation, practically against their will or without their knowledge. So the compulsory acquisition does not deal with cases where the government is negotiating to buy a piece of land. It occurs when government wants a piece of land and decides to take it for a public purpose, and the law sets up a mechanism. There are 2 laws which govern that. First is the Constitution, which says that government can only take your land compulsorily if they follow a law specially designed for that purpose. And that law, which is specially designed for the purpose of the acquisition of land by the government, is the Land Acquisition Act, Chapter 322. And it is that act I intend to read. I wouldn't get through more than 6 sections if we're lucky. But this will be the last for the time being, because I don't like to do 4 programs on the same topic. Probably at a later time I may come back. All right. So the Land Acquisition Act is the law which the government, any government, must follow if they are going to acquire anybody's land compulsorily. And I want to recap the sections I have already read. The first 2 sections don't really concern us today. Section 3. If the Governor General, and Governor General in laws means the Cabinet, if the Governor General considers that any land should be acquired for a public purpose, he may cause a declaration to that effect to be made in the manner provided by this section, and the declaration shall be conclusive evidence that the land to which it relates is required for a public purpose. Basically what this section is saying. If Cabinet decides it wants a parcel of land on behalf of the government for a public purpose, they publish a declaration said government wants this land for X purpose, and they have to specify the purpose. And once that is done, the law presumes that the land is required for a public purpose. Subsection 2. Every declaration shall be published in 2 ordinary issues of the Gazette, and copies thereof shall be posted on one of the buildings, if any, on the land, or exhibited at suitable places in the locality in which the land is situate, and the declaration shall be specified, and in the declaration shall be specified the following particulars relating to the land which is to be acquired. A, the parish or district in which the land is situated. B, a description of the land giving the approximate area and such other particulars as are necessary to identify the land. C, in cases where a plan has been prepared, the place where and the time when a plan of the land can be inspected. And D, the public purpose for which the land is required. Subsection 3, and this is the one which I emphasized the last time, and this is the vital section of the whole land acquisition procedure. Subsection 3. And this is the one which you have to understand, and there's no quarreling with this. That is the law. You may not like it, you may disagree with the government acquiring this or that parcel of land, but this is what the law says. Subsection 3. Upon the second publication of the declaration in the Gazette, the land shall vest absolutely in the Crown. So when that notice comes out for the second time in the Gazette, automatically the land belongs to the government. You may say, well, how that can that be? Well, that is the law. But when I say belongs to the government, it is subject to the right of the landowner to get compensation for the land. Government can't just take your land and don't compensate you for it. But all the government has to do if it wants a piece of land for a public purpose is to publish a declaration in the Gazette saying, we want to acquire this particular piece of land, and give a general description of the land for a public purpose and state the public purpose. First publication comes out in the Gazette. Next week, the same publication comes out a second time, and the law says when that second publication comes out in the Gazette, the land automatically belongs to the government. What the landowner is entitled to is to compensation, but the landowner cannot stop the government taking the land if it is required for a public purpose and if the government has gone through the legal procedures. Now, subsection 4 goes on to say what I said just now. Nothing in this section shall be deemed to prevent the acquisition of land for public purposes by private treaty. In other words, nothing in the law shall be deemed to prevent the government buying land. That is, negotiating to buy the land from a landowner. Nothing to stop them. It's just that we are dealing with compulsory acquisition. That is, if the landowner doesn't particularly want to sell and the government said they want that piece of land for a public purpose. Now, the law stresses public purpose. That is what the Constitution has mandated. The government cannot take people's land for private purposes. Now, subsection 4, and these are all important qualifying subsections. Section 4. If it appears to the Governor General that any land is likely to be required for any purpose which, in the opinion of the Governor General, is a public purpose, and it is necessary to make a preliminary survey or other investigation of the land, he may cause a notification to that effect to be published in the Gazette. And thereupon, The authorized officer and his agents, assistants, and workmen may do all or any of the following things. That is to say, A, they may enter upon the land and survey and take levels on it. B, they may dig or bore into the subsoil of such land. C, they may do all other acts necessary to ascertain whether the land is adapted to such purpose. D, they may set out boundaries of the land intended to be taken. E, they may mark levels and lines by placing marks and cutting trenches. F, where otherwise the survey cannot be completed, the levels taken or the boundaries or line of the work set out, they may cut down and clear away any standing crop, fence, tree, or bush. C, they may do all such other acts as may be incidental to or necessary for any of the purposes aforesaid, provided that the authorized officer shall not enter into any building or into or upon any enclosed yard, court, or garden attached to a dwelling house, except at all reasonable hours, and except with the consent of the occupier thereof, without previously giving to such occupier at least 7 days' notice in writing of his intention so to do. What this section is saying, if the government is interested in a parcel of land, but they're not sure if they want to acquire it, but they are interested in using the land for a public purpose, they can publish a declaration in the Gazette saying, look, we are interested in checking out this parcel of land to see if it is suitable for a purpose we have in mind, which is a public purpose. And once that is published in the Gazette, the authorized officer, which in our case has been for the past 40 years the chief surveyor, he can go with his workmen and check out the land, investigate, do levels, dig parts of the land, cut down trees and so on, to see if that land is suitable for what the government wants. Now, if the government decides that land is not suitable, having sent the chief surveyor and his men to dig up and cut down and so on, the government will be liable to pay compensation to the landowner for any damage caused by those preliminary investigations. But the law gives a government the right, upon publication of a notice to that effect in the Gazette, to investigate land that they have in mind to acquire for a public purpose. Excuse me. And just to read what I said just now, provided further that compensation shall be paid to the person interested in the land so entered for any actual damage or injury resulting to them by reason of the exercise of the powers conferred by this section, and shall be assessed, and the law gives the method of assessing. Section 5. If at any time after the publication of a notification in accordance with the provisions of Section 4, that is, if at any time after the powers I just read out to you, it appears to the Governor General that the land or some part of the land to which it refers should be acquired, but that for any reason it is not possible to make an immediate declaration to that effect, the Governor General may direct the authorized officer to do any work on the land or parcel thereof connected with the use to which the land is intended to be put on its acquisition, and thereupon the authorized officer may proceed with the execution of the work. So if when the government checks out a parcel of land, it decides, look, we're not ready for that land yet, but we are sure we're going to be ready for it at some future time. The authorized officer can go ahead and do all that which I pointed out in the section before that he is entitled to do. Because section 5 goes on to say, provided that compensation shall be paid to the persons interested for any actual damage and so on and so on. Now, I have to speed up because, as I said, I want to get through at least section 6. Section 6 has 2 subsections. 1. As soon as any declaration has been published in accordance with the provisions of section 3, that is, they decide they want this land for public purpose. What this is saying, as soon as the declaration is published, the authorized officer shall, without delay, enter into negotiations or further negotiations for the purchase of the land to which the declaration relates upon reasonable terms and conditions and by voluntary agreement with the owner of the land. So, government publishes notices in the Gazette. We want this piece of land for a public purpose. After the second publication, the land belongs to the government. What the law is saying, as soon as possible after that, the authorized officer must enter into negotiations with the owners of the land for assessment of compensation. Now, subsection 2 is important, and because of the fact that many people don't know about subsection 2, it is necessary for me to read it carefully. It shall not be necessary for the authorized officer to await the publication of the declaration before he endeavors to ascertain from the owners the terms and conditions on which he is willing to sell his land. But no negotiations nor agreement shall be deemed to be conclusive unless and until the conditions of sale and acquisition have been approved in writing by the Governor General. So the law is saying, look, the authorized officer hasn't got to wait for publication of notices. He can go ahead and try to negotiate the purchase of the land from the owners of the land. But the authorized officer cannot conclude any deal with the owners of the land until Cabinet has approved the same. Now, what this really means is that the government has many options to choose from when the government wants to take a parcel of land from a private owner to be used for a public purpose. Lots of things the government can do lawfully according to the law. So the fact that the government chooses to do one thing rather than another doesn't mean necessarily that they are breaking the law. The law gives the government a wide choice when they are interested in private land. Now, one would say that because we're a democratic country, things should be done in as civil a manner as possible, and that is a reasonable stand for anybody to take. Remember, I gave you the joke about what happened in the days when the government of St. Vincent and Grenadines was planning to acquire the Orange Hill estate. The owners of the Orange Hill estate, through their lawyer, negotiated with the Danes to sell the estate to the Danes, knowing that the government full well wanted the land to cut up for local farmers. And when the Prime Minister, Mr. Sir James Mitchell, checked the lawyer and said, well, look, the government is now ready to talk buying. The lawyer laughed and said, son, you're too late. Who tell him to say that? It's the worst thing he could have said to Mr. Mitchell. Mr. Mitchell just got mad when he reported to us in cabinet. They're telling the Prime Minister you're too late. And he set about compulsory acquiring the property and put the money in the treasury for the Danes to, or whoever the local owners and so on to get. Too late. Government can never be too late when it comes to acquiring land, because the law is based on the old English land tenure system, which really says basically all land belongs to the Crown, or used to belong to the Crown, and the Crown therefore has a right to take it back upon the payment of compensation when the Crown is ready. Now, I will have a little time to go into section 7. It says, section 7.1, as soon as may be after any land has been acquired compulsorily, the authorized officer shall, if the boundaries of the land have not been set out or if they cannot be identified by reference to any plan, cause the same to be set out, and he shall also issue a notice of acquisition in accordance with the provisions of this section. Again, some people have been saying that how could government acquire land in Murray's Village and they have not even identified the specific piece of land, exactly how many square feet. Well, that can be done after acquisition. This is what the law is saying. As soon as maybe after any land has been acquired compulsory, the authorized officer shall, if the boundaries of the land had not been set out, or if they cannot be identified by reference to any plan, cause the same to be set out. So it is up to the authorized officer to then, after the land has been acquired, to then identify with specificity the exact piece of land which has been acquired. Now, the rest of the Land Acquisition Act is very interesting, and as I said, I encourage people who are really interested to ask a lawyer to give them a photocopy of the law, because the law gives enormous powers to the government. And finally, as I had indicated last week, in case of the Murray Village dispute, dealing with the land for the MacLean family, which some people have been saying it's the Murray's family. No, the MacLean family. This Dr. Murray married into the MacLean family. And that land is not far from the Nanton land, which we acquired from the Nanton family, well, at least from the bank, Agricultural Credit and Loan Bank, Mr. Randolph Russell, in 1987. The government went through the law. They published the first notice on the 28th of July 2020, and then they published the second notice on the 5th of August 2020. So as far as the law is concerned, what the government did with that MacLean land at Murray's Village was in accordance with the Land Acquisition Act. Government did not violate anybody's rights. You may say, okay, they should have discussed it. I agree with that, fair enough. But I don't know the extent to which they might have attempted to discuss it. But to say they should have discussed it doesn't mean to say they had a duty to do so before it was acquired. No, that is not what the law has said. All right. So Brother Oti, on whose behalf this topic has been done at his request, I hope you are satisfied that I have done my civic duty by explaining what the law is. And in the case of at least one person writing in one of the local publications who said that some lawyer should come and explain the law. What happened is that person has been sleeping. That person doesn't know that a program called The Law and You exists, and that explanation has been done and it's continuing to be done. So my brothers and sisters, ladies and gentlemen, boys and girls, this is where I leave that topic for the time being. Those interested can get a hold of a photocopy of the Land Acquisition Act, Chapter 322, and read it, and you will be enlightened to see the enormous powers the government has when it comes to acquisition of land. But what the landowner has is the right to fair compensation, and the law sets out a mechanism by which that compensation is to be assessed by a board of assessment chaired by a high court judge, and a panel comprising of the judge as chairman, a representative of the government, and a representative of the landowner. All right? All right, well, that is all from this program of The Law and You, program number 985. I look forward to being of further service to you next week, Wanda Divi, for another presentation in this public service nation building series, The Law and You. Do have a pleasant week, ladies and gentlemen, brothers and sisters, boys and girls, and may the good Lord continue to bless us all.
The Law and You, a look at laws in St. Vincent and the Grenadines which affect our daily lives. The Law and You, presented by lawyer panel P.R Campbell QC, and brought to you on SVG-TV as a public service.